Application proceedings. Application is utilized where it is mandatory to do so and prescribed by statute or where there is no real dispute of fact. This is a dispute capable of a decision on the papers before and no viva voce evidence is adduced. This is the difference between deciding an action and an application. Which proceedings may be brought by an application? The Act and rules provide for applications to be brought in a number of instances. The two main categories of applications are interlocutory applications or applications for substantive relief. Certain applications, also referred to below, have their own procedure and must therefore not be brought in terms of Rule 55. General requirements for applications. The relief brought by means of an application must be permitted by the actor or the rules. The person wishing to make the application or the applicant must compile a written notice of the application, except where otherwise provided for, either in the Act or the rules. Notice of the application must be given to any party affected thereby. In the case of Pennington Health Committee, and in the 1980 case, it was held that even if Act 32 of 1944 had vested magistrate courts with jurisdiction in application for orders authorizing the sale of rateable property, it would not have been competent for the magistrate to grant this application for the simple reason that it was made ex parte. In the case of Klassen versus Zeneca, it was held that an applicant was not obliged to bring an application for an interdict in terms of Rule 56 on an ex parte basis. Application for an interdict may be brought ex parte. The notice must cite as respondents all persons who have a material interest in the relief sought. In terms of Rule 55, Section 1C, this includes any party who may be affected by any order as to costs which the court may make. This was also mentioned in the case of Defontaine Consolidated Gold Mines versus I can't even pronounce that, but you can see the case number and the name of the case. The terms of the order sought must be stated shortly in the notice of motion. The notice must contain the date and the time when the order will be sought. The notice must be delivered to the respondents at least 10 days before hearing thereof. 20 days where the state is the respondent. The notice must be endorsed with the name and address of the applicant. The notice should be signed by the registrar or his or her party's or her legal practitioner. The requirement is not found in Rule 55 itself, but it is established in practice. In addition, Form 1 provides signature of the applicant or his or her legal practitioner. Duty of good faith in ex parte application, the applicant must observe the utmost good faith prima fides when approaching the court for a relief. This implies that he or she should make full disclosure of all the relevant facts in his or her papers. All facts which may influence the court, whether in favor of the applicant or to refuse the application, should be set out. Does a supporting affidavit form an essential part of an application? Well, Rule 55(1) provides that every application should be brought by a notice of motion and must be supported by an affidavit to the facts upon which the applicant relies for relief. There are, however, instances provided in terms of Rule 55 where affidavits are not necessary or may be dispensed with by the court. Rule 55 makes provision for the following distinct procedures. Application on notice, and in this regard, unopposed applications, opposed applications, which may further be divided into those that can properly be decided upon an affidavit and those that cannot. Ex parte applications, interlocutory and other applications incidental to pending proceedings, application to court for authority to institute proceedings, or directions as to procure or service of documents, application for striking out any affidavit matter which is scandalous, vexatious, or irrelevant, the joinder of parties to an application or counter applications. Withdrawal of an admission. Further examples of a case where an affidavit would need to be provided in support of an application for the withdrawal of an admission. In general, an amendment for a pleading to withdraw an admission will not be allowed unless evidence is put before the court to show a reasonable basis for that withdrawal of the admission. It is established in practice that evidence must be adduced in support of such application. It must, however, be remembered that a party may amend his or her pleadings even if such an amendment amounts to withdrawal of an admission without the intervention of the court if the other party does not object to the amendment. This is in terms of Rule 55A, subsection 5. Please note, however, that an affidavit is a document by means of which a sworn evidence is put before court in written form. An amendment of an affidavit would amount to a change of evidence which has been given under oath. An amendment thereof cannot be allowed by way of mere notice under sub-rule 55A. A party in such circumstances must prepare an affidavit explaining his or her reasons for requiring an amendment for his or her affidavit. Affidavits. When an affidavit is used in support of the application, what should that affidavit contain? The applicant's affidavit should set out the facts upon which he or she relies. This also applies with the necessary changes to the respondent's answering affidavit. The following must be apparent from the affidavit. Appropriate allegations to establish the local standing of an applicant should be made in the launching affidavits. The case of Scott versus Scott and others versus Haneko, it was held that depending on the facts of the case, implied allegations regarding the applicant's local standing may be sufficient. And this is also in the case of David versus Lube and others. Facts indicating that the court has jurisdiction to entertain the application's ex parte. A cause of action. The case of Cilius versus Tutoy, the evidence in support of the application or facts upon which the applicant relies must be contained in the affidavit. According to the case of Moverberger versus Moverberger, it is not for the applicant to simply make general allegations. And when those allegations are dealt with, in reply, come forward with replying affidavits giving details supporting the general allegations or originally set out in the affidavit supporting the notice of motion. It is settled law that in replying affidavits, an applicant is not allowed to set forth details of allegations which should have appeared in the original affidavit supporting the notice of motion. So it's important to actually clearly, when drafting the application, state all allegations, draft all allegations properly to avoid basically such instances. Inclusion of the new material or an objection thereto is as follows. Although the rule is not absolute, this applies save in exceptional circumstances. This was mentioned in the case of Bayet and others. It must always be borne in mind that the rules of procedure are made to facilitate litigation and that therefore they are always subject to overriding discretion of the court. In the case of Shepherd versus Tucker's Land Development Corporation, if the founding affidavit is so defective or is defective in that it does not disclose a basis of the relief sought, the application is defective and the applicant cannot for the first time make his or her case in the replying affidavit. Yeah, also emphasizing the previous point. The number, in the case of Jay's Properties versus Turgan, the number of affidavit allowed in application. There are 3 sets of affidavits usually allowed: the application's founding affidavit, the respondent's answering affidavit, the applicant's replying affidavit. The court has a discretion to permit further or filing of affidavits on good cause shown, and if the rules applicable to the particular applications so allow. Now let's look at ex parte applications. In the case of Simros Ventus versus Verulam, it was stated that an ex parte application is simply an application of which notice was, as a fact, not given to the person against whom the relief is claimed in his absence, and that the unilateral nature of such proceedings in their most prominent feature as subrule 55, subsection 3, limits ex parte applications to those in respect of which the court is satisfied that giving notice to a party against whom the order is claimed would defeat the purpose of the application. The degree of agency is so great that it justifies dispensing with the notice. Rule 55.3 says as follows: no application in which relief is claimed against another party shall be considered ex parte unless the court is satisfied that giving notice to the other party against whom the order is claimed would defeat the purpose of the application, or the degree of the agency is so great that it justifies dispensing with the notice. Notice of motion in every application brought ex parte shall be similar to Form 1 of Annexure 1. Any order made against a party on an ex parte basis shall be of an interim nature and shall call upon the party against whom it is made to appear before the court on a specified return date to show reasons why the order should not be confirmed or not be made final. Any person against whom an order is granted ex parte may anticipate the return day upon delivery of not less than 24 hours notice. A copy of any order made ex parte, the notice of motion and of the affidavit, if any, on which it was made shall be served on the respondent thereto, while cause is shown against any order made ex parte against a party, the court may order the applicant or respondent or the deponent of any affidavit on which it was made to attend for examination or cross-examination. Any order made ex parte may be confirmed, discharged, or varied by the court on cause shown by any person affected thereby, and on such terms as to costs as the court may deem fit. Rule 55, subsection 7, the court, after hearing an application whether board ex parte or otherwise, may make no order thereupon or thereon, save as to cost, if any, but grant leave to the applicant to renew the application on the same paper, supplemented by such further affidavits as the case may require. Applications continued. Let's look at interlocutory applications. Interlocutory and other applications incidental to pending proceedings must be brought on notice, corresponding substantially with Form 1C of Annexure 1. Section 36, what judgments may be rescinded? Court may, upon application by any person affected thereby, rescind or vary judgments granted in the absence of the person against whom that judgment was granted. Let's look at Rule 49, rescission and variation of judgments. A party to proceedings in which a default judgment has been granted may, within 10 days after obtaining knowledge of the judgment, serve and file an application to the court on notice to all parties to the proceedings for a rescission or variation of the judgment. The court may, upon a good cause shown, or if it is satisfied that there is good reason to do so, rescind or vary the judgment on such terms as it deems fit, provided that 20 days period shall not be applicable to request or rescind a variation judgment, or in terms of Rule 5, it will be presumed that the applicant had knowledge of the default judgment 10 days after the date which, unless the applicant proves otherwise. Rule 49, rescission and variation of judgments. Annual Rule 49 came into effect on the 1st of August 2018, in terms of which a debtor or any other person affected by the judgment may apply to rescind the judgment if the judgment debt, the interest thereon, at the rate granted the judgment, and the costs have been paid in full. The application must be made on a form corresponding substantially with Form 5C, Annexure 1, and proof of payment must be attached. The application must be served on the judgment creditor 10 days before the hearing. Where the application for rescission of a default judgment is made by a defendant against whom the judgment was granted, who does not wish to defend the proceedings, the applicant must satisfy the court that he or she was not in willful default, and that the judgment was satisfied or arrangements were made to satisfy the judgment within a reasonable time after it came to his or her knowledge. Let's look at Rule 69, compliance with the rules, including time limits and errors. Where any order is not willfully complied with within the time so stated, the court may, on application, forthwith give judgment in the action against the party so in default, or may adjourn the application and grant an extension of time for compliance with the order on such terms as to cost and otherwise as may be just. The court may, on application under sub-rule 60, section 2 and 3, order such stay of proceedings as may be necessary. Any time limit prescribed by these rules, except the period prescribed in Rule 51, section 3 and 6, may at any time, whether before or after the expiry of the period limited, be extended by written consent of the opposite party. And if such consent is refused, then by the court on application and on such terms as the court of otherwise as it deems fit. Let's look at section 32, attachment in security of rent. Upon an affidavit or on behalf of the landlord of any premises situated within the district that an amount of rent not exceeding the jurisdiction of the court is due, and in areas in regard to the said premises, and that said rent has been demanded in writing for the space of 7 days and upward, or if not so demanded, that the deponent believes that the tenant is about to remove movable property upon the said premises in order to avoid payment of such rent, and upon security being given to the satisfaction of the clerk of the court, and to pay all damages, cost charges with the tenant of such premises or any other person may sustain or incur by reason of the attachment hereinafter mentioned. If the said attachment be thereafter set aside, the court may, upon application, issue an order to the messenger requiring him to attach so much of the movable property upon the premises in question, and subject to the landlord's hypothec for rent as may be sufficient to satisfy the amount of such rent, together with the cost of such application and of any action for the said rent. For application in terms of Section 32, Section 1 may be brought ex parte under Rule 56. In this case, there's sufficient reason to use ex parte procedure because notice this to the respondent would defeat the object of the application, namely, to attach movable property before the tenant is able to remove the goods from the leased premises. The purpose of an attachment on the ground of an apprehension that the tenant is planning to remove the movables in order to avoid having to pay the overdue rent is not only confirm the hypothec and render the removal of the goods unlawful, it is also attachment in the securitatem debit. Editor citation and substituted service. In terms of the previous magistrate court rules, applications for substituted service could be brought in the magistrate court, but not those for an editor citation. The situation now has now been clarified, and editor citation is now provided in Rule 10 of the rules, in line with granting the regional court's matrimonial jurisdiction, and the new rules provide for applications for maintenance, pendated litem, contributions, interim custody, and access to children. Editor citation is ordered when the defendant is or is believed to be out of the Republic. Substituted service is where summons or order of the court is served by way of a publication in newspaper or other publication. It must be published in the language of the newspaper or any other method of service. Applications in respect of irregular proceedings. Rule 60, subsection A, or Rule 60A, apologies. Where an opponent it has taken an irregular step, the other party may now apply for the court to have it set aside. The irregular steps must be in respect of the rules of the court, and the rules does not serve as a basis to object to the procedural irregularities in respect of other legislation. Rule 5, subsection 11, which provides that if a party fails to comply with any provisions of Rule 5, such summons shall be deemed to be an irregular step, and the opportunity and the opposite party shall be entitled to act in accordance with Rule 60A. When the defendant fails to comply with the magistrate court, admit, deny, confess, or state all the material facts, set out necessary explanation of qualification of denial, properly tendered, the plaintiff may use Rule 60A to address the issue. If the defendant counterclaims, the claim in reconvention must comply with Rule 20, failing which it will be deemed an irregular step and the other party may act in accordance with Rule 60, subsection A.